Hi there. My name is Laurel Damaris, and today I am going to be presenting my research that I conducted over the summer. My title is A Person's a Person No Matter How Small, or How States Should Be Empowered to Handle Matters of Child Custody. And this research is something that is very significant right now, especially as far as how my research affects the existing literature. The background as to why this topic is important is that the prevalence of child abuse cases have steadily increased over the years, especially the last 50 years. There has been a huge rise in the number of children that become involved with the DCFS system. The DCFS system is the state system that is responsible for determining whether parents still have rights in their children and the custody situation of children who have been abused or neglected. In the 2018 fiscal year, 58.5 children per 1,000 children became involved with the DCFS system at some point during that year. That number increases every year consistently, especially between 2014 and 2018. That number has increased by about 2 children per 1,000 every year. In the year 2018, there were 939 reported child fatalities. So reported child fatalities refers to the records that DCFS keeps regarding children that have passed away, whether that be in the custody of their parents. Basically, the records show reported child fatalities that have to do with suspicious circumstances, specifically children that have been involved with the DCFS system. And of those 939 children, 30% of them had previously been reunified with their abusers due to the current DCFS system's push for family reunification. So reunification is the ultimate goal of DCFS. It has been for a long time and still is. And reunification just refers to when the state becomes involved and removes children from their families. The goal is always for the children to end up back with their guardians who have rights in them. The goal remains and always is to restore that relationship wherever possible. And reunification is not necessarily a bad thing, but it is significant that 30% of the children who passed away in 2018 had previously been reunited with their abusers, which means that the state recognized there was some reason to remove that child and then intentionally put them back with that same abuser who ultimately caused the death of the child. And those statistics come from the U.S. Department of Health and Human Services. And the 2018 report on child abuse statistics is the most recent report. So with all that being said, my thesis is due to the rising number of children becoming involved with the DCFS system, the Supreme Court must enable states to return to what is known as the best interest of the child standard concerning matters of child custody. Essentially, reunification remains the top priority of DCFS. And the Supreme Court has made it very difficult for states to be able to intervene in abuse situations and permanently terminate parental rights. The Supreme Court has changed the standards around throughout the course of history in a way that makes it very difficult for states to terminate the rights of parents in their children. This is the list of cases that I used in my thesis. There obviously are years of Supreme Court cases at play here. They all sort of play off of one another, build off of one another. But there are 3 cases that are central to my argument, and those are the cases that I'm going to talk to you about today since we are pressed for time. The first case I'm going to talk to you about is a case called Quillen v. Walcott, which is a 1978 case. In this case, the Georgia courts at the time would assess facts and hearing of parental fitness and determine what would be in the best interest of the child. So it was on an individual basis that the court would determine what was best in that one situation for that one child. And that is known as the best interest of the child standard. So whenever the court looks at the facts of the situation and assesses whether that child should remain with their custodial guardian or they should be removed from that situation, the court making that determination was known as the best interest standard. And in 1978, in this case, the Supreme Court ruled in favor of this best interest of the child standard. The court, in the majority opinion, vocalized that this was a rational and good faith attempt from the state to do what is best for the child. The state has an interest in children as citizens because they will grow into having full rights and having full citizenship, and the state has an interest in protecting that. And because the state has an interest in protecting that, it is rational for the state to want to be able to assess what would be best for children who are in difficult custody situations. This opinion was unanimous, so that means that all 9 justices agreed there was just one opinion, and they determined that this case was not a violation of equal protection or due process of the 14th Amendment. Equal protection and due process of the 14th Amendment are typically where we find liberty rights grounded. And the language of the 14th Amendment has to do with the process that you are due for any type of trial, which is the due process clause, and equal protection, which refers to how the laws apply to you as compared to others. And the court said that the best interest standard did not violate due process, meaning that the rights of the parent were not violated by the best interest standard because they were still given a trial regarding their parental fitness. And equal protection was not violated either because this is something that applied to everyone. The best interest standard was used very widely in the state of Georgia at the time. And the court in 1978 believed that this was okay. And I would agree with this, that the best interest standard is the correct standard to use when assessing who children should be in the custody of in regards to their home situation. So the next case that I want to talk about, and this is a case that is really important for my argument because I feel like this case is incorrect and was ruled incorrectly, is a case called Santosky v. Kramer. This case was decided in 1982. At the time, a New York law allowed for the state to terminate the rights of parents and their natural children, despite parental objection, based on the finding of permanent neglect. So this means that despite what the parent has to say about the situation regarding their children, the state was able to terminate those rights if permanent neglect had been found. And in order for a finding of permanent neglect to be established, the New York Family Court Act required only a fair preponderance of evidence standard of abuse and neglect. And a fair preponderance of evidence is a very, very low bar to meet for evidentiary requirements. That's very low. So the state basically just has to suspect that the child is being neglected to terminate the rights of the parent. And in this case, the Supreme Court ruled that the fair preponderance standard was in violation of the due process clause of the 14th Amendment. They said that the process due in parental rights termination proceedings must balance 3 separate factors. And those 3 separate factors are the private interest affected by the proceedings, the risk of error created by the state's chosen procedure, and the countervailing governmental interest. All of this means that a fair preponderance of evidence standard was just too low to warrant taking away parental rights. The bar was too low. States could easily meet this and easily take parental rights away. And the court said that the due process clause demands that the burden of proof used must reflect weighing of those 3 factors. And because the loss of the child from their parents would be permanent, we see the shift to clear and convincing evidence. So the court decides that we should get rid of the fair preponderance standard and shift to the need for clear and convincing. So clear and convincing essentially is, do you believe beyond a reasonable doubt that the child has been neglected versus I suspect the child has been neglected. So it raises the bar that the state has to meet to remove the rights of parents. The next case that I want to discuss is Troxell v. Granville, which happened in 2000. Troxell v. Granville, I want to discuss because Santosky v. Kramer opens the door for Troxell to happen. So in Troxell, a Washington state law permitted any person to petition for custody to a child at any time, despite parental objection. And Washington courts were to grant visitation based solely on what would best serve that child's interest. So once again, we see the best interest of the child standard. The Supreme Court ruled that the Washington statute was in violation of the 14th Amendment liberty rights of parents because there was no discretion given to the parents. You could not object once the court decided that it was in the best interest of your child to have visitation with any other adult. The court determined that this was too sweeping and left no room for deference to parental discretion. And in this case, the court also said that state involvement in parental decisions is only warranted upon the finding that a parent is unfit. And these three cases kind of carve out the cornerstones of why states cannot intervene more than they do in child abuse cases. And so the issue that I have with the rulings here is mainly with Santosky v. Kramer. And I would propose that Santosky v. Kramer is overturned, which would allow states to return to a best interest standard. Santosky goes a step beyond and goes too far because the Santosky ruling results in the conflation of the fair preponderance of evidence standard and the best interest of the child standard. So although best interest and fair preponderance are referring to two completely different things, those have become conflated, and by proxy, Santosky has gotten rid of the best interest of the child standard and does not allow states to use that standard anymore. I think that's where Santosky goes too far, and by overturning Santosky, we would allow states to return to using the best interest of the child standard. And in Quillen, we see the court determine that the best interest standard is constitutional and reasonable, and that it aids in the duty of the state to protect children from abusive situations. Santosky undoes this, undoes what Quillen does, by asserting that the best interest standard and the fair preponderance standard are the same thing. They are not the same thing. They have become conflated, but the result is that the best interest standard does not meet the heightened evidentiary requirements imposed by Santosky. So I would propose overturning Santosky to allow states to, once again, start assessing what would be best for individual children in individual situations. And I believe that this would result in a drop in the number of children who become involved with DCFS. I think that this would result in a drop in the number of child deaths that occur every year, because that number increases and has been for years. I think that post-Santosky has left room for children to remain in abusive situations. And the only way that we can effectively protect children at a state level is to overturn Santosky v. Kramer and allow states to revert back to the best interest standard. Right, so thank you for your time. Thank you for watching this video and listening to my research. And if you have any questions, I would be happy to discuss those with you because this is something that is very important to me and close to my heart. So yeah, thank you.